So let's talk just for a moment about rights that people have after trial's over. Let's start with double jeopardy. Can you tell us about that?
Double jeopardy is the concept that you can't be tried twice for the same crime. But that's the concept. We have to drill down a little deeper when we're talking about double jeopardy. Because when we talk about double jeopardy, what we're really saying is that the same sovereign can't try you for the same crime. So, for example, let's assume that we're thinking about the LA situation with Rodney King back in the 1990s. You had police officers who were tried at the state level and who were also tried at the federal level. Some folks said, that's unfair, that's double jeopardy. Turns out that that's not double jeopardy. The idea is the state may try you for one set of crimes. The federal government may try you for a different set of crimes. Now, the state can't try you twice for the same crime, and the federal government cannot try you twice for the same crime. But if the state tries you for one set of crimes and the federal government tries you for another set of crimes, that's not double jeopardy. So we want to be clear that when we're talking about double jeopardy, we are literally saying the particular jurisdiction cannot get a second bite at the same apple.
A defendant also has the right to appeal after a guilty verdict. That right can encompass substantive issues that are relevant to guilt, as well as procedural issues that are relevant to a trial's fairness. However, the prosecution has no right to appeal an acquittal, that is, a not guilty verdict.
Is double jeopardy enumerated in the Fifth Amendment?
The double jeopardy is enumerated in the Fifth Amendment.
And then, of course, there's the Eighth Amendment. And so let's talk just for a moment about excessive fines and cruel and unusual punishment. What do you want to tell us about that?
Excessive fines and cruel and unusual punishments are both about limiting what it is that the government can do to us. It's one of those circumstances where we say, look, if there is a crime, that is perfectly acceptable. Well, it's not acceptable, you're guilty. But if there's a crime, there should be a particular punishment that is provided. And that punishment ought to be inside the realm of what's reasonable to punish. So when we talk about excessive fines, we're talking about fines that are just well outside of the realm of what seems to be appropriate for this particular conduct. Who makes that decision? That's a different story. But the idea is you can go overboard when it comes to punishments. The same thing is true about cruel and unusual punishments. When we talk about cruel and unusual punishments, we're talking about things that might seem like torture. And I'm not talking about just basic torture if it's so torturous to go to jail. I'm talking about actual torture. I'm talking about the rack, putting folks in places where all you're doing is inflicting pain for no purpose other than inflicting pain. In those circumstances, we say, as a civilized country, we just don't do those kinds of things. We will punish you. We will punish you harshly. We will punish you appropriately. What we will not do is too much. When we talk about an eye for an eye, some people think an eye for an eye means total vengeance. Not necessarily the case. What an eye for an eye arguably means is there's a limitation on vengeance.
There is some debate about whether sentences that appear to be particularly long, given the crime at issue, can qualify as cruel or unusual punishment. Many Supreme Court justices agree that at some point sentences can become so disproportionate to the crime that the sentence triggers an Eighth Amendment violation. Similarly, particularly harsh prison conditions can qualify as punishment that violates the Eighth Amendment. That a defendant has been convicted does not mean that the defendant loses his or her humanity.
That limitation on vengeance is what we're actually looking at, and that is a big part of what we're talking about in terms of the excessive fines piece and the limitation on cruel and unusual punishment.
I assume, though, if we put out someone's eye, that would be an Eighth Amendment violation these days.
That would be an Eighth Amendment violation to actually put out someone's eye. Absolutely correct.
Well, no punishment is more extreme than the death penalty, so can you tell us the arguments that can be given regarding whether or not capital punishment should be considered a constitutional violation?
Death penalty as a constitutional violation is a matter of dispute among a number of justices. The problem that we run into is that capital punishment has been allowed since the beginning of the Republic, and certainly since well before in other cultures. So the fact that we have allowed it and have not eradicated it suggests that, at least as a constitutional matter, it's very unlikely that it was supposedly barred by the Eighth Amendment. Now, That being said, there may well be circumstances where we have decided, in fact, there are circumstances where we've decided that the death penalty is not an appropriate punishment. And indeed, that's one of the pieces of the puzzle that we ought to consider, is under what circumstances is the death penalty allowable. And when we step back and ask under what circumstances is the death penalty allowable, we may have to ask, well, should there be more circumstances under which the death penalty is not allowed? The Supreme Court's position is that the death penalty is largely for the worst of the worst homicides. That is a key issue, the worst of the worst homicides. First, we have to determine what does it mean for the death penalty or for a crime to be the worst of the worst. Those issues tend to be defined by states based on what the states decide they believe the worst of the worst means. However, the Supreme Court has generally taken the position, although we're not absolutely certain, but has generally taken the position that you've got to be talking about homicides. Rape, no matter how bad it is, some folks argue that's not a legitimate basis for the death penalty. It may well be the case moving in the future that maybe child rapes may qualify, but as of right now, nothing qualifies other than homicide.
Has the Supreme Court put any other limitations on states that do use the death penalty other than homicide as being the reason to administer the death penalty?
There are limitations on the death penalty in terms of what crimes may trigger the death penalty. There also are limitations depending on which defendants we're talking about. So, for example, children cannot be put to death. For example, folks who are mentally disabled, depending on the standard used, also cannot be put to death. The concept is that folks are supposed to understand why it is that they are being put to death. A little ironic in that you can't execute someone until they understand why they're being executed, and at that point we can then decide to execute them. It's a very interesting notion.
We'll deal with other rights in the Bill of Rights and other lessons, but obviously, based on the discussion we've had today, the rights covered in this unit are, needless to say, incredibly important. What lessons, underlying or major lessons, do you think we should learn from an examination of these rights?
The examination of the particular rights that we've seen trigger the idea that we've got to think about what is the relationship between the citizen and the citizen's government. With the rights that we've talked about, First Amendment rights, Fourth Amendment rights, Fifth, Sixth, Eighth Amendment rights, we're talking about the relationship that an individual has to society and to government. Some of those rights we talk about seem to be God-given rights or creator-given rights. Some of those rights are created by the fact that government exists, namely how we deal with trials and post-trial situations. So when we think about the structural study of the Bill of Rights, we want to think about where it is the person, the citizen, happens to reside in the Constitution. We have to think about that in terms of how the individual reacts and interacts with the federal government, as well as how the individual acts and reacts with respect to and interacts with respect to the state government. In some ways, the Bill of Rights arguably is the Constitution today, to the extent that we tend to look to the Constitution as the place where we find our rights.
Professor Chambers, thank you so much. This has been very enlightening. Thank you again.
I appreciate you having me.
I want to thank Professor Henry Chambers for his comments and his expertise, and I want to thank you for your participation. Please join us next when we discuss Unit 6.